Defendant's behalf. The defendant Robert Kelly, better known as R. Kelly, was a renowned recording artist, and in April of 2008, he announced that he would be embarking on a national tour called the R. Kelly Double Up Tour. For the promoters of this tour, Defendant Kelly turned to defendant Leonard Rowe and Rowe Productions, Inc. This decision was made in full acknowledgement that Rowe and his company would be responsible for all matters pertaining to the tour, giving them the authority to act on his behalf in all capacities related to the event. World was led to believe that Rowe and his company were the authorized representatives and agents of Defendant Kelly. In this regard, Defendant Kelly was able to rely on his promoters to have a successful tour. Robert Kelly, known to the world as R. Kelly, was a superstar in his own right. Everyone wanted to hear him perform on the Double Up Tour. Little did they know, the tour was being coordinated and promoted with the help of Leonard Rowe and his company, Rowe Entertainment, Inc., with the contracts authorized by R. Kelly himself. All parties were poised to make a big impact with the R. Kelly Double Up Tour. Everyone was excited to see what the national recording artist could bring to the stage. However, soon after the tour began, a legal battle ensued between R. Kelly and Leonard Rowe, eventually reaching the courts. The truth of who authorized the contracts and how greatly unfair Leonard Rowe had acted was now up for debate. An articulated advisor to defendants, Robert Kelly aka R. Kelly and Double Up Tour. The representatives, who acted with actual and apparent authority on behalf of the defendants, made it clear that they were offering the plaintiffs the chance to become a 50% partner in the R. Kelly Double Up Tour. The representatives made sure to emphasize the potential gains to be had in both the short and long run, and to ensure that the plaintiffs remained confident about their decision. In the weeks prior to the tour, the representatives were engaged in a flurry of activity, including numerous interviews, publications in newspapers and other forms of mass media, as well as several promotional activities. This helped to spread the news of the tour, as well as further establishing the legitimacy of the plaintiff's partnership with Leonard Rowe, aka Len Rowe. As a result, public acceptance of the tour and Leonard Rowe was now at a much higher level. On the day of the tour's launch, all of the participants, both plaintiffs and defendants, seemed to equally share in the excitement. As the tour progressed, so too did the audience's enthusiasm. By the end of the tour, participants were incredibly proud of their achievements, and the hoped-for financial gains were realized. The R. Kelly Double Up Tour was a great success, due in no small part to the dedication of the representatives and Leonard Rowe, and of course, the plaintiffs, whose embrace of the opportunity not only yielded them great financial benefit, but also allowed them to become a part of history. The atmosphere buzzed with anticipation as the crowd together to maximize the potential of the Indiana debut of R. Kelly's national tour, creating a partnership of quality and excellence. Terrance L. Kinnard was impressed with the business proposition and enthusiastically joined Rowe Entertainment, Inc. as a partner. Unfortunately, on the day of the show, the vendors and sponsors were not paid as they had been promised, and the floor staff, couriers, security personnel, and other associated employees were not compensated for their services. Understandably, the show was a complete disaster, and the staff and vendors lost a great deal of money. In the aftermath of the event, both Leonard Rowe and Rowe Entertainment, Inc. were held liable for their deceptive business tactics and lack of honoring their obligations to vendors and employees. They were required to pay a large sum of money in damages. Terrance L. Kinnard, on the other hand, was not held liable since he was not a part of the organizing team. He suffered tremendously in terms of his financial losses and his reputation, but was relieved that he was not held liable for the defendants' actions. Tour company to be R. Kelly's supporting cast. The promoter was ecstatic. The tour they had been promoting for months had finally arrived. They had worked numerous late nights and tireless early mornings to promote the biggest R&B concert tour in history. This was a major achievement, as it was unique and unprecedented in the industry. R. Kelly was the star of the show. His unique and sought-after performance was the main reason for the success of the tour. He was the name in the tour's title, which bore his likeness. Copyright and trademark. It was clear that the other acts were in support of R. Kelly. The tour spanned multiple cities and managed to pack sold-out crowds. Everywhere R. Kelly and the other performers went, they received adoring fans that sang along to every song and danced with R. Kelly to every beat. It was the biggest R&B tour in history, and there was no doubt that the promoter did an outstanding job of promoting it. Their lead consultant was a powerful, successful African-American businessman who would serve as a mentor and advisor to promoters seeking access to established artists and performances. The defendants used Leonard Rowe's presence to attract investors, calling him a powerful, successful African-American businessman who could mentor aspiring promoters wanting to further their career. Without any knowledge of the real purpose of the organization, unwitting victims were enticed to join the organization in the hopes of accessing established artists like R. Kelly and other artists. Little did these naive investors know, the organization had much more nefarious intent and merely sought to gain access to resources and money through their racketeering activities. Needless to say, the promised benefits never materialized, and Leonard Rowe's role in the organization was mostly false pretenses. In what can only be seen as a classic case of bait and switch, the defendants were exposed and brought to justice. On October 17, 2007, both the plaintiff and defendant, Rowe Entertainment, Inc., executed a contract for a musical performance in a live concert set for Saturday, December 8, 2007, in Indianapolis, Indiana at the Conseco Fieldhouse. As stipulated in the contract, the plaintiff was to invest a sum of $120,000, $120,000 with the said defendant. Little did plaintiff know that Rowe Entertainment, Inc. was a corporation used by all of the defendants to directly receive proceeds to advance their pattern of racketeering activity. The plaintiff was relieved to make the required payment and excited to confirm that everything was in place to proceed with the business arrangement. After booking the flight to Atlanta, Georgia, the plaintiff anxiously made their way to the airport in anticipation of their meeting with Leonard Rowe. The plaintiff was met at the airport and driven to a restaurant for a 3-hour luncheon to discuss the details of the partnership. During the meal, the plaintiff and Leonard discussed every aspect of the agreement to ensure that both parties were in agreement. The plaintiff was delighted to note that things were progressing smoothly throughout the meeting. Finally, at the end of the 3 hours, the parties shook hands and headed for the airport. Satisfied with the results of the negotiation, the plaintiff made their way back home, feeling deeply grateful for having taken the initiative to pursue this lucrative opportunity. The future of the partnership looked very bright indeed. For 7 weeks, Leonard and Rowe Entertainment, Inc. remained in contact to ensure that the upcoming concert on December 8 was adequately promoted and planned. Leonard was consistently reassured by the progress they were making towards the national tour. He was elated as the excitement of the tour began to mount and the anticipation grew each day. The weeks leading to the event were filled with endless conversations about potential promotions, advertising strategies, and security arrangements. There was an unmistakable mutual enthusiasm between Leonard and Rowe Entertainment. As the days flew by, The night of the concert finally arrived, and the room was filled with a euphoric atmosphere. Leonard was overcome with a sense of pride, joy, and amazement. He and Rowe Entertainment had worked together tirelessly, and the results of their effort were evident, a sold-out show with a thrilled audience. Leonard couldn't have been more pleased. Throughout their meetings leading up the concert, Leonard, Rowe, and Rowe Entertainment, Inc. were filled with promise of the upcoming show on Saturday, December the 8th. When Leonard spoke to Robert Kelly, aka R. Kelly, they always discussed just how knowledgeable R. Kelly was about the prospective success of the tour. Both were looking forward to the grand night that was to come. Nothing would stand between them, and on Thursday, November the 15th, 2007, plaintiffs arrived in Columbus, Georgia to attend the meeting with defendants, Robert Kelly, aka R. Kelly. To everyone's surprise, what appeared to be a relaxed rehearsal period actually turned out to be quite intense. Plaintiffs realized that the meeting was an opportunity to showcase their marketing strategy, as well as their enthusiasm for the Indianapolis date and the national tour. Fortunately, they were able to effectively communicate their intentions, which resulted in tremendous success for the national tour. In the end, everyone was satisfied with the outcome of the meeting. On November the 16th, 2007, plaintiffs and their assistant Leonard Rowe arrived in Atlanta, Georgia to view the extraordinary concert execution orchestrated by defendants Robert Kelly, aka R. Kelly, and Leonard Rowe and Rowe Entertainment, Inc. The defendants were generous enough to provide the plaintiffs with concert tickets, as well as full access to the backstage, production, promotion, and VIP areas. The plaintiffs were blown away by the incredible experience. After the concert, the plaintiff and defendants, Rowe Entertainment Inc., discussed the spectacular performance at length. They shared their appreciation for all that had been done to bring the concert to life. It was a truly memorable night for everyone who witnessed the show. On December the 8th, 2007, the plaintiff arrived at the Conseco Fieldhouse prepared for a meeting with the defendants, Leonard Rowe and Rowe Entertainment, Inc. At approximately 1:00 p.m., the plaintiff had made all the necessary calls confirming the meeting place and time. Little did the plaintiff know what was in store for them at this meeting. As the clock slowly ticked towards 1, a sense of anticipation and excitement filled the air. The plaintiff waited patiently for the defendants to arrive, eager to discuss the live performance that was to take place at 7:00 p.m. that evening. Unbeknownst to them, the meeting would be much more than just a discussion. On December the 8th, 2007, the plaintiff was informed by defendants Leonard Rowe and Rowe Entertainment, Inc. that their previously scheduled meeting would have to be rescheduled. Initially, the new meeting was set for 3 p.m., but the plaintiff was then informed by the defendants that the meeting was once again being rescheduled, this time for 6 p.m. The plaintiff was exasperated at this constant change in plans, but nonetheless prepared for the meeting, hoping that the situation would work out in the end. It was the eve of December the 8th, 2007, when the plaintiff had what was supposed to be a rescheduled meeting with the defendant. But when the day came, there was no answer from the defendant on his cell phone, nor any response to any messages left. It was as if the defendant had just disappeared. The plaintiff and his staff soon came to the realization that the defendant had adopted a new stance, and the plaintiff started to question the staff of the defendants. But still, no answers were given. It was then that the plaintiff knew that something was awry, and that plans had changed. The plaintiff became filled with anger and frustration from the defendant's sudden absence. After all, the two had a meeting that was supposed to take place. His unanswered questions only made him more suspicious. In the end, it seemed that the defendant had no intention of meeting that day, or any time soon. The plaintiff had alleged that they had attended a meeting in Indianapolis with Leonard Rowe and Rowe Entertainment, Inc., the defendants, in order to discuss contractual matters. After an exhaustive inquiry, the plaintiff determined that the defendant's staff was unaware of any such meeting, and did not know if the defendants were even in the state of Indiana at the time. Following several rounds of questioning, the plaintiff was informed that Leonard Rowe had not traveled to Indianapolis as part of the discussion. With that, the plaintiff felt they had no choice but to honor the contract that had been executed, and therefore agreed to participate in the accounting of all proceeds and expenditures for the aforementioned concert. It was a normal day in the office when William R. Sims, Jr. was told that he had to lead the settlement. He was an accountant for Leonard Rowe and Rowe Entertainment, Inc., and was responsible for the financial side of things. William had done this kind of work many times before, and was confident that he could do it today without any problems. He worked diligently as he tabulated and tallied up the sales, profits, and losses. After an hour or so, William had the final results in front of him. He double-checked the numbers several times to make sure everything was accurate. Finally, he wrote up a formal report to go to Leonard Rowe and Rowe Entertainment, Inc., outlining the final results of the settlement. William was proud of his work and knew that his bosses would be happy with the results. He had done a thorough job, as was customary in the industry. William takes satisfaction in knowing work and that his work had a lasting and impact on the institutions he won helping. This was the true sense of accomplishment. The plaintiff was outraged. They had made the arrangements and went to great lengths to make sure this concert was successful, and now they weren't being compensated properly. After a full day of negotiation and holding their ground, the plaintiff was finally able to get a reasonable settle agreement. When they entered the management offices, they were shocked to find out that the agreement the defendants had made with the venue resulted in a net loss for the partners. Despite this, William R. Sims, Jr. still received a cash payout from the venue. This blatant injustice was the final straw for the plaintiff, and they brought this information to light during the settlement. Ultimately, the plaintiff's perseverance paid off, and they were able to secure the settlement that they deserved. They vowed to never let this happen again, and to always make sure that the partners are properly compensated for their hard work. William R. Sims, Jr. and Leonard Rowe of Rowe Entertainment, Inc. had enticed the plaintiff into signing a business agreement. They promised that any losses from the venture would be rolled over into an upcoming concert in Florida. As part of the agreement, the plaintiff was promised a 50% partnership interest in the concert scheduled for December 30th, 2007 in Jacksonville, Florida. The two men seemed confident and assured, creating a sense of trust and security in the plaintiff. They sold him on their vision and exclaimed that the concert would be a great success. Little did the plaintiff know, he had been duped and misrepresented. When December 30th, 2007, rolled around, there was no concert to be seen. On December 28th, 2007, the plaintiff took a trip to Charleston, SC to meet with the defendants, Leonard Rowe and Rowe Entertainment, Inc. Upon meeting, the defendants reiterated their partnership in a concert scheduled to take place on December 30th, 2007 in Jacksonville, FL. They then set a specific time for the two parties to meet once more in Jacksonville just prior to the concert's start time. Little did the plaintiff know that this meeting would be the beginning of the contractual journey, wherein their mutual dreams would slowly begin to come true. The plaintiff traveled to Jacksonville, FL to meet with the defendants at the Radisson Hotel on December 30th, 2007. However, the scheduled meeting was unilaterally canceled without notice as the defendant, Leonard Rowe and Rowe Entertainment, Inc. did not respond to his calls or any of the messages sent. suspecting a new posture initiated by the defendants. The plaintiff confronted their staff and demanded answers. He wanted to know the reason why the meeting was canceled, and why he was not informed of it. The staff was hesitant to answer but eventually disclosed that the two parties had differing interests, and they would not be able to come to a resolution. The plaintiff was infuriated and immediately filed a lawsuit against the defendants for not properly informing him about the cancellation. He was furious that they had lied to him, and thus the legal process began. The plaintiff had made a claim that Leonard Rowe and Rowe Entertainment, Inc. had agreed to a settlement in Jacksonville, Florida. After an intensive investigation, the plaintiff learned that not only were the defendants not aware of such a meeting, they could not guarantee that the defendants were ever physically in the state of Florida. After several more questions, the plaintiff was then informed that Leonard Rowe had not traveled to Jacksonville himself, but instead William R. Sims, Jr. had handled the settlement on behalf of Leonard Rowe and Rowe Entertainment, Inc. So the plaintiff had no legal evidence to support their claim. John, a successful businessman, was convinced by the Rowe defendants to invest in a business venture. He believed their promises of lucrative returns, and invested a total of $120,000. After a certain amount of time passed, it became clear that these promises were lies, and John realized he had no chance of receiving any profits from his investment. Heartbroken and disheartened, John took the Rowe defendants to court for civil conversion. In his motion for default judgment and motion for summary judgment, John requested treble damages in the amount of $360,000. Under the rules of civil conversion, the court agreed that this was allowed, and concluded that John had been wronged. He was awarded the full amount of $360,000 in recompense for the money he had lost. The plaintiff arrived at the management offices in Jacksonville, FL, expecting to take part in the settlement. However, the defendants blocked entry to the offices, preventing the plaintiff from entering. The plaintiff was unable to participate in the settlement, and started researching in hopes of uncovering the truth. After monitoring the conclusion of the R. Kelly double-up tour, the plaintiff began to uncover information that showed the partnership opportunities were in fact a scam. Each defendant was found to have engaged in fraudulent conduct, with evidence proving they had lied to secure gain. The plaintiff was appalled by such behavior, and decided to take legal action. With the truth now known, the plaintiff was determined to get justice. It was a criminal enterprise, spanning across multiple cities, states, and even countries. The scope of the criminal activity was astounding, and the perpetrators were equally impressive. At the center of this criminal enterprise were 4 individuals, each with their own unique skills. One had the resources and know-how to manipulate markets, all while making sure the profits landed in their coffers. Another was a master of disguise, able to make sure the origin of their criminal proceedings were kept hidden. A third had the technical knowledge to sneak past the firewall of any system. And the fourth was a master of deceit and manipulation with a wealth of contacts and networks. Each of the 4 carried out fraudulent activities. But, more importantly, their collective activity amounted to a pattern of racketeering, which had a massive, long-term impact on society. The court concluded that these 4 individuals, with their unique sets of skills, engaged in a collective venture of criminal activity that could not be overlooked. An. Code An. 342431 are assault, battery, and invasion of privacy. John was minding his own business when he suddenly felt a searing pain on his right side, and spun around to see a malicious-looking figure who had just inflicted a battery upon him. Feeling vulnerable and exposed, John had his sense of privacy stolen from him through the terror of the individual in front of him. Knowing the wrongs that had been done to him, John quickly sought justice and went to court. Ind. Code Ann. 3424-31 allows a person who suffers a pecuniary loss after being the victim of certain crimes to bring a civil action against the person who caused the loss. John filed his motion for default judgment against the malicious figure, citing for the 3 crimes: assault, battery, and invasion of privacy. He claimed an amount which couldn't exceed 3 times the actual damages, seeking for the costs of the action, a reasonable attorney's fee, and all other reasonable costs of collection. After hearing John's arguments, the court granted him the relief he claimed, and the malicious figure was held accountable for the wrongs done to John. The court followed the plaintiff's complaint, which listed counts of civil conversion, theft, and deception. The plaintiff requested treble damages for the conversion, making the court believe they were attempting to bring a civil action to recover for criminal conversion. The court then began to look further into the civil conversion issue. Per Ind. Code Ann. 3424-31, the court determined that the plaintiff was entitled to treble damages. This meant 3 times the value of the property that was wrongfully taken was owed to plaintiff by the defendant. The court knew it had to assess the legal relationship between the parties to understand the precise value. After exhaustive consideration, the court ruled that the plaintiff was owed the treble damages in addition to compensatory damages for theft and any emotional distress related to the deception. Plaintiff brought suit against defendant for criminal conversion, seeking damages for unauthorized exertion of control over their property. In their complaint, plaintiff requested punitive damages. Unfortunately, their motions for default judgment and summary judgment did not discuss or request punitive damages. The court examined the case under Indiana law and determined that defendant did indeed commit criminal conversion. However, since plaintiff did not mention punitive damages in either of their motions, the court did not discuss or award punitive damages. It was ruled that the only damages awarded were those that relate to the damage defendant caused to plaintiff's property. Leonard, Rowe, and Rowe Entertainment had a plan. They were sure they could get away with it. They ran a scam that involved taking advantage of someone's misfortune, and they were sure they wouldn't get caught. Little did they know, they were in for a rude awakening. Plaintiff had been struggling financially, and so when Leonard, Rowe, and Rowe Entertainment promised plaintiff a 50% partnership in the Indiana concert and the profit sharing that came with it, they were more than happy to hand over their $120,000. It was all too good to be true, and it was. When plaintiff's money was handed over, the Rowe defendants made sure to create the false impression of a partnership interest, making them believe that they were really going to receive something out of this. All the while, Leonard, Rowe, and Rowe Entertainment knew that no partnership interest actually existed. The truth of the matter was that the Rowe defendants were all too aware that the money they were taking was never going to return to the plaintiff. Unfortunately for the Rowe defendants, the justice system was unmerciful. The court came to the conclusion that the Rowe defendants had knowingly taken the money from plaintiff, making false promises in the process. The Rowe defendants were held accountable for their actions, and the court ruled in favor of the plaintiff. Plaintiff had been taken advantage of. After giving the Rowe defendants $120,000 in hopes of securing a partnership interest in the upcoming concert in Jacksonville, he realized too late that they had never offered a partnership in the first place. Defendant Sims was implicated in the matter, but only because he had a hand in settling the concert in Indiana. Along with the Rowe defendants, plaintiff remembers him promising the partnership, but it wasn't until after he had already paid the $120,000 that he realized he'd been swindled. Now, plaintiff is trying to get the money he believed he'd rightfully earned through the partnership back. He seeks to recover the $120,000 he originally paid out. Determined not to be taken advantage of like that again, Plaintiff had a strong case. He had collected evidence showing that the Rowe defendants had wrongfully taken his property valued at $120,000. So, in an effort to punish them for their misdeeds, Plaintiff requested treble damages in addition to actual damages, bringing the total damages requested up to $360,000. To ensure he would be rewarded fairly for his losses, Plaintiff also requested post-judgment interest as provided by law. All that was left for the court to decide was if the Rowe defendants were guilty of wrongfully taking Plaintiff's property, and if so, how much they would have to pay. The court carefully considered the request for attorney's fees requested by the plaintiff. Section 3424(3)(1 of the Indiana Code was considered, and it was accepted that the plaintiff was entitled to recover a reasonable attorney's fee. The court allowed the plaintiff to present evidence regarding the number of hours worked in this case and the hourly rate charged. The clock hour system was used to evaluate the amount of time that was spent representing the plaintiff. The challenged fee request was then analyzed to determine whether the hours were reasonably expended, taking into account the nature and complexity of the case as well as the efforts and results obtained. The court finally arrived at its analysis and found that the $21,061 in attorney fees requested by the plaintiff was a very reasonable amount, and it was accepted. The court thus found in favor of the plaintiff in the amount of $21,061 for attorney fees. Experience. Glenn Holskamp was the plaintiff's counsel in a significant and revealing case, a case replete with complexities and fees, and most importantly, a need for legal advocacy. Mr. Holskamp's meticulous attention to detail was reflected in his billing statements, which estimated a total cost of $21,061. The fee, a whopping $465 per hour, though Mr. Holskamp defended the rate as reasonable. Citing the Laffey matrix as reference, there was no empirical evidence to support his claim. Nonetheless, the fee was paid and the case was closed, a victory for the plaintiff, and ultimately for justice. After a long battle in court, justice was served on the 2nd of March 2010. Plaintiff, who fought for what was right, was awarded a total of $369,816. This included $360,000 in damages, $8,750 in attorney's fees, and $1,066 in costs. All other claims against the Rowe defendants were denied. Judge Forrester issued a directive that the Rowe defendants were to pay the agreed-upon amount that same day. It was a satisfying conclusion for all those involved that justice was served. Terrance L. Kinnard marched happily into the courtroom as he was confident in the justice that awaited him. It was the culmination of a long, hard-fought legal battle with Rowe Entertainment Inc. and Leonard Rowe that had started when the company had awarded him a contract that was worth $360,000 in damages. Terrence had been trying to get justice for a long time, and it seemed that the result was just within his grasp. The judge listened to Terrance's motion for a summary judgment and motion for default judgment before proceeding to rule in favor of the plaintiff. The judge ordered that Terrance receive the full $360,000 in damages, along with attorney fees of $8,750 and costs of $1,066. The court date was set on the 3rd day of March 2010 in Atlanta, Georgia, and Terrance could not be more pleased with the result. Justice had been served and Terrance had won his case. The long journey was finally over, and it was indeed a very satisfying day.
You are watching Diva Divine Light. You can fuck with me if
These is red bottoms, these is bloody shoes. Hit the scoop, I can get them both. I don't wanna choose, and I'm quick. Cut a nigga off, so don't get comfortable. Look, I don't dance now, I make money move. Now I gotta dance, I make money move. If I see you now speak, that means I don't fuck with you. I'm a boss, you a worker, bitch. I make bloody move. Now she say she gon' do what a hoop. Let's find out and see. Cardi B, you know where I'm at, you know where I be. You just a party, I'm there, I can play. I be in and out the bank so much, I know they tired of me. Honestly,